Good morning. May it please the court. My name is Michael Wasiq. I'm here on behalf of Appellant Leslie Long. Your Honor, I'd like to reserve 5 minutes.
Sure.
Today we're here seeking reversal of a foreclosure judgment at trial of the foreclosure of the homestead of Leslie Long by Nationstar. Now, we have presented multiple issues in our brief, but today we want to focus on one of those issues unless the court has questions about the other issues that we've raised. That issue is standing at inception, something I know the court's well familiar with. In the initial complaint filed by Aurora Loan Servicing, Nationstar later substituted in, the initial complaint had 2 counts. The first was for foreclosure of a mortgage. That count attaches a note with no endorsements payable to a third party, not Aurora, not Nationstar. It also includes a lost note count, pleading that Aurora did not have possession of the note at the time it filed suit. Later, that complaint was amended. The amended complaint for the first time included allonges with endorsements on them for the note and dropped the lost note count. At trial, the issue came up of whether or not the plaintiff was able to prove possession at inception of the lawsuit and standing at inception of the lawsuit. Now, the briefing by the bank in this case states that they pled that they're the servicer on behalf of the true owner of the note, Deutsche Bank Trust Company of America. And the note that is attached to the amended complaint has an endorsement to Deutsche Bank as trustee, but doesn't list a specific trust. There's no indication of when that endorsement was applied, and there's no indication of when, if ever, the servicer, well, at some point they did because they presented a note at trial. There's no indication of when they recovered possession of that note that they originally thought was lost. Now, it's important when the bank claims to be proceeding as the servicer. 673.3011 Florida statutes provides 3 prongs for enforcing a note. One is to be the holder. That means you have to have possession and endorsement, or it can be directly payable. The second is to be a party in possession, a non-holder in possession, with the rights of a holder. So that would be the type of situation where you'd have a servicer acting on behalf of the actual holder that had specifically delegated to the non-holder the rights to enforce. Because certainly a non-holder doesn't get holder rights out of nowhere. They have to get them either from the holder or the owner or something to that effect. And there has to be some kind of evidence of that fact. The third prong, which doesn't really apply here since the complaint was amended, generally deals with a party not in possession that has lost the note and is seeking to reestablish. There's some other exceptions in there that aren't part of this case. It's our position that at trial, the evidence did not show that, or there was no evidence introduced, that Nationstar, as the substituted plaintiff for Aurora, had standing at inception by virtue of Aurora's standing inception when they stepped into the shoes of Aurora, because they did not show any date on which the parties took possession of the note or any date on which the endorsement was applied. And specifically, on cross-examination, the pages 29 through 31 of the transcript, the trial transcript, show that the witness, the bank's witness, I personally conducted the trial. I asked the question. I said, are the endorsements dated? They're not. Is there any record when the endorsements appeared on the note? There's not. Is there any record when the bank took possession of the note? There are no records, and I don't know, is what she said in substance. But that's on pages 29 to 31 of the transcript. So it's very clear that there was no evidence of standing at inception based on possession or based on endorsement. Therefore, there was no proof of the holdership of the note in inception, and because Nationstar and Aurora were claiming standing through the servicing for the holder, through Deutsche Bank, because they failed to prove that Deutsche Bank was a holder, they don't have any greater rights than that of the principal that they are purportedly the agent for. So it's our position that they failed to prove standing. Now, it's our position that this case closely tracks the May versus PHH case, which we cite in our brief, and I know the panel's familiar with. In the May case, the issue came up where the original complaint had no endorsements, but the amended complaint did. And then at trial, the plaintiff failed to prove the date on which the endorsements were applied. Now, the May case not only says you have to prove the endorsements, it also says you have to prove possession. But in that case, it was the endorsement, the proof of endorsement that failed. Now, it's our position that this case is even more egregious than the fact pattern in May, because in May, based on the opinion, the failure of proving the endorsements was the only failure. Here we have two failures: the failure to prove date of possession and the failure to prove the date of endorsement. So it's our position that they failed all the way around. In addition, the standing issue fails because it's our position they failed to prove that Nationstar and its predecessor Aurora were servicing this loan on behalf of the endorsed plaintiff, because there were no records, and again, this comes up in the transcript, there were no records that named the specific trust or any specific trust that was in the power of attorney that was relied on by Nationstar at trial. The power of attorney listed several trusts for which they purported to have servicing rights, but none of those were connected to this particular loan. So they failed to connect that dot as well. There's multiple breaks in the chain that they would have to show, because not only do they have to show that their principal had standing by being the holder or the owner, then they had to show that they had authority specifically to service this particular loan, which they failed to do because the evidence they introduced dealt only with trusts that had nothing to do with this loan. There was no evidence connecting this loan to that particular power of attorney. There was no other evidence linking this loan to this servicer, or rather this servicer to this principal for this particular loan. You sound like you have a question.
I do, and I'm looking at a power of attorney. And this is appointing Nationstar. Now, are you talking about that power of attorney or power of attorney appointing the Nationstar's predecessor?
I think that's the only power of attorney that was introduced at trial.
Okay, because and again, I may be missing it in the gray of the type here, but it looks to me like what it's listing is a series of loans, correct?
Your Honor, the exhibit to the power of attorney listed a series of trusts. And in other words, oftentimes plaintiffs are listed as Deutsche Bank as trustee for such and such trust. The exhibits to the power of attorney in that case listed a number of trusts, none of which were connected in any way to this particular
All right,
loan.
well then my copy must be, because all I have is an Exhibit A that lists like Residential Loans, Inc., Series 2007,
Those are names of trusts.
Those are names of trusts?
That's correct.
Okay.
And that was elicited at trial, Your Honor. So there was...
and there was nothing to connect this loan to any of these?
That's correct, Your Honor. In fact, specifically, I directed a question to the witness saying, is there any document here today that connects this loan to any of the trusts listed in the power of attorney? The answer was no. Let me see if I can find that. That's on, I believe it's page 29 of the transcript. And that is line 18. Question, okay, do any of the records that have been introduced so far mention the specific name of the trust that supposedly governs this loan? Answer, I don't believe they did. So that's addressed.
That begs the question, because if Thompson, the records custodian, could not connect it up to this particular loan, nor could she testify as to when the plaintiff came into possession of the note, and she had no way of telling when Deutsche Bank came into possession of the note, what evidence did the bank establish or the servicer establish and this court relied upon to show standing?
I don't think they did introduce evidence. That's the issue. Now the bank's brief claims that they introduced a letter indicating that Aurora was the servicer, and we've addressed that in a reply brief that you can't connect the dots that way. That's the Lacombe case out of the first DCA that we cite in our reply brief. I think that if you're going to prove up date of possession, date of endorsement, you have to say, look, here's the records that show when we received custody of the note. Here's the custodial records. If we're going to show endorsements, like here's the record if we scanned the note the day we got it and it had the endorsements on it that day. That's something that is easily done in most foreclosure cases. It wasn't done in this case, and we don't know why.
Did they rely on the assignment? That's a July 2012 assignment.
Well, that assignment of mortgage, Your Honor, they don't rely on that to show standing because they can't. It postdates the filing of the complaint.
Okay.
It only indicates that whatever Aurora had went to Nationstar, but
assignment from the servicer to servicer.
That's correct. And I think the under questioning the witness actually answered that it only transferred servicing rights, because if it transferred ownership of the note, then that defeats because they've pled that somebody else owns the note, not Nationstar, not Aurora. So they can't introduce that as evidence that conflicts with their pleadings. They can't plead that somebody else owns the note and then come in with an assignment that says, well, Aurora owned it, now we're transferring it to Nationstar, not without connecting the dots. They have to make if they were going to claim that Deutsche Bank transferred it to Aurora and then Aurora transferred it to Nationstar, they would have to introduce some kind of evidence of that fact that predated the complaint, and that they didn't even assert that theory, let alone try to introduce evidence of it. So I don't think that meets their burden in this case. So unless the panel has any other questions or would like me to address any of the other issues in the brief, I'm going to reserve the remainder of my time.
Okay.
Thank you very much.
Thank you.
May it please the Court, Mark Gottlieb of Ackerman LLP on behalf of the appellee, Nationstar Mortgage. The foreclosure judgment that was entered in this case by the trial court was supported by competent substantial evidence, uncontroverted by any evidence offered by the appellant in this case, and should not be disturbed. It comes to this court cloaked with a presumption of correctness as to all the factual findings, including reasonable inferences that could be drawn from the facts that were adduced at trial. At the end of the day, and as is typical in a lot of these cases, there was no dispute below that the appellant executed the note and mortgage, took this loan, received the benefit of the loan, defaulted by failing to make payments dating back to June of 2008, and has remained in possession of the property without paying the mortgage for the last 6 years, while Nationstar and its predecessor have paid taxes, insurance, taking every action consistent with somebody who has the right and entitlement to enforce the mortgage. And no one else has ever materialized during that 6-year span saying, hey, wait, no, we're the ones who have the rights under this mortgage. We're going to seek to enforce it. We're going to pay the taxes. We're going to send default letters. We're going to take actions consistent with those of an owner, holder, or party entitled to enforce under 6733011.
Well, I think we appreciate the fact that the evidence demonstrates that the borrowers were in the home beyond default for an extended period of time, but we're constrained by the law that requires you to prove that you had possession of the note at the time of filing complaint. If your records custodian testified that she had no idea when you came into possession of the note, and there was no way of telling when you came in possession of the note, what documentary evidence established that?
The documentary evidence, we concede that there was no piece of paper admitted into evidence at trial, a custodial record showing that on the date that this action was filed, that note was in the possession of plaintiff or Deutsche Bank. The record is what it is. We believe that the evidence supports an inference that the party, the named plaintiff here, was in possession, was entitled to enforce this instrument by virtue of the totality of the facts here, that they had possession of the instrument with an allonge, with an endorsement at the time of trial and surrendered that to the court, that they were the ones servicing this loan from day one, sending the default letters, keeping the records, consistent with what people entitled to enforce instruments do. And again, the posture of this case is important. In almost every case that appellant relies on, the cases were decided on summary judgment. So for example, Feltus, Gonzalez, Cutler, all decided in the context of summary judgment. And the standards and burdens are much different in that context. In that context, it's the affirmative obligation of the plaintiff to essentially disprove the affirmative defense of lack of standing, to demonstrate affirmatively that there's no issue. We had a trial here, and the appellant at that trial presented no evidence whatsoever to support its defense of standing, and no evidence to controvert the evidence presented that there was only one party here who ever was entitled to enforce and acted to service this loan, and that was Aurora, and then its successor Nationstar, all as the servicer for Deutsche Bank trustee. And in terms of that link that's alleged to be missing, there is information in the record that does actually connect the dots with respect to that. Judge Northcutt, you noted that there was a power of attorney. That power of attorney, which says that it's going from Deutsche Bank as trustee to Nationstar, and also notes that it's that Nationstar as successor to Aurora, and then even Aurora's predecessor, attaches as a list, an exhibit, a series of trusts for which the power of attorney pertains. Mr. Wasiq introduced and questioned the witness about a motion for summary judgment that identified the specific trust on whose behalf Nationstar serviced. And that trust was the Residential Accredit Loans Trust Series 2006 Q05. The Series 2006 Q05 trust is one of the trusts identified in the power of attorney that was admitted into evidence at trial. In addition, in the record, admittedly not addressed at trial, but in the record, there is a motion for substitution of Nationstar as a party. And the evidence submitted in support of that motion, and that motion was ultimately granted, included hello and goodbye letters sent pursuant to RESPA. And if you take a look at the hello letter that comes from Nationstar in 2012, it specifically says, we're taking over servicer as servicer of your loan, and it specifically identifies the trust. The Residential Accredit Loans Series 2006 Q05 trust, which is in that power of attorney that was introduced. So there is a connection, connecting the dots in the record between the particular trust on whose behalf Nationstar serviced and this particular loan.
Well, that's dated after you filed your complaint.
The power of attorney?
No, the hello letter. You filed the complaint in April 2011. The hello letter is July 2012.
Yes, but the argument that was being made was that Nationstar at the time of trial didn't, there wasn't a connected dot to show that Nationstar was servicing and proceeding to foreclose this loan on behalf of this particular trust, and that this particular trust was associated with the loan. That's a business record that establishes that the two things are connected. And there was also questioning at trial regarding a motion for summary judgment in an affidavit that identified that particular trust, and the court could certainly look at the two documents and notice that there was a match between what had been identified as the trust that held this loan and what was identified on the power of attorney that was admitted into evidence in this case. At the end of the day, this court has expressed reservations in the past in the Folk decision regarding this rigid requirement of having to prove physical possession at the time the action was filed, recognizing the practical realities of mortgage loan servicing and foreclosures, and that in 2008, most people didn't keep track of when they placed an endorsement on a note or when they came into possession. They came into court with the original instrument endorsed in blank or endorsed to a particular party, and that was enough to foreclose. I think in a concurrence in Folk, it was even suggested that maybe it's time for a rule change where if you have possession at the time of trial, at the time of summary judgment, that is sufficient. This court doesn't need to go that far in this case. I think that in this case, the trial court is permitted to make reasonable inferences from the evidence presented. I think it's reasonable to infer that when you're servicing the loan, you've set it up on your servicing systems, you have physical possession at the time of trial, you are the one paying taxes, insurance, communicating with the borrower, sending default letters, and there is no countervailing evidence whatsoever that anybody else had possession or was entitled to enforce. And while this loan has been in default for 7 years, no one else has ever materialized saying, no, it's our loan, we're entitled to enforce it. That from those circumstances, the trial court should be permitted to infer standing, entitlement to enforce at inception. Alternatively, I would ask that the court look at standing and the lack of standing as what it is, which is an affirmative defense. And while at summary judgment, it might be the foreclosing plaintiff's burden to disprove that defense, at trial, it should not be. And that when evidence is presented establishing the existence of the loan, the servicing of the loan, the default, the sending of default letters in compliance with conditions precedent, and all of that is done, that it should be the burden at trial for the plaintiff to come forward and say, no, you didn't, here's proof that you weren't the party entitled to enforce, that you didn't have possession. And I think that sets this case apart from many of the cases that they've cited. If, conceitedly, if there is a rigid rule that says you must walk into court with a custodial record showing that on September 22nd, 2008, you had possession, that document doesn't exist in this case. Again, we think inference is permissible. And I would just say that in most cases, there is an inference being made by the trial court judge of possession at the time of trial. Take, for example, in some cases, the evidence of possession may be a Bailey letter that goes from the servicer to foreclosure counsel. Often that Bailey letter may be sent 5 months before the case is commenced. At the end of the day, the trial court is inferring that the named plaintiff had possession at the time of the commencement of the foreclosure based on the fact that there was a transmittal of that to counsel 5 months before. There's not a piece of paper that says on that day they had it, but they're making a logical inference. I think the same can be done in reverse. Mortgage foreclosure defense has turned into a lot of gameplay, and I think that's something that the court recognized and invoked, where there's no dispute here as to what transpired, that there was a note, that it wasn't default, and this is again being used as a mechanism sort of to game the system and allow somebody to remain in possession for a very long period of time when there's really no dispute and there's nobody else out there entitled to enforce this instrument. Unless there are further questions, I will request that the court affirm the lower court's judgment. Thank you.
Thank you. I don't want to beat a dead horse, so I'm going to be as brief as possible. First of all, this is certainly not a game to Leslie Long, whose home is at stake here. I wanted to, because I wanted to just clearly state the relief we're requesting in our brief, which is we're asking for a remand for dismissal based on insufficiency of the evidence pursuant to the Correa and the Wolkoff cases that we've cited in our brief. That's the relief we're looking for. Based on the insufficiency of evidence of standing in this case, we believe that's appropriate. Counsel made reference to the cases that we rely on as being summary judgment cases. Our 4 best cases, however, are trial cases. The May case, which this panel is familiar with. The Ryan case from the 4th DCA that we cite is also a trial case. The Kiefert case and the Lacombe case that we cite in our reply briefs. Both of those are trial cases as well, and all of those revolve around standing at inception. Virtually every DCA that's weighed in on the issue of standing at inception, I can't think of an exception, has lined up with the requirement that a plaintiff has to prove standing at inception. Now, is the custodial record the only way it can do so? Not necessarily, but it's certainly the best way. They didn't come close to their burden in this case.
Let me ask you about Exhibit 3. The complaints filed in April 2011. Exhibit 3 is the breach letter that was admitted without objection. It does indicate that Aurora Loan Services is notifying your clients of the default right to cure, and it's dated July 28, 2008. Does that not create an inference that they either possess the note with the rights of a servicer to foreclose?
I don't think it creates an inference as to either possession or as to endorsement, because the initial complaint by Aurora said it had neither. And also, too, the inferences that counsel's asking you to draw are contrary to those that are in the record. He mentioned, for example, the affidavit, the power of attorney. If you refer to page 33 of the transcript, I specifically asked the witness about that, asking the witness to compare the limited power of attorney to the affidavit. I asked, does it mention mortgage asset-backed pass-through certificates as being the name of any of the trusts that authorizes Nationstar to service? Answer, it does not. Okay, so the affidavits filed by Nationstar or filed by Aurora in December of 2012 identifies a different trust than those in the power of attorney. So the power of attorney introduced at evidence at trial, according to the witnesses, and I'm sorry, she goes on to say that's correct. So according to the witness's testimony, The limited power of attorney that they rely on to show evidence of standing, to show the servicing relationship, lists in different trusts than the one that they're relying on in the affidavit for summary judgment, but they don't connect the dots there. So that they can't say that they're the same they can't ask this court to make the inference that they're the same when the direct trial testimony of their own witness says that they're different. Finally, I wanted to address the point where the idea that standing is an affirmative defense and should be proven as affirmative defense. The cases that I mentioned, May, Ryan, Kiefert, and Lacombe, all put the burden on the plaintiff to prove standing at inception. If it's denied, and that's proper because standing is something that it's their burden to plead, and if it's denied, it's their burden to prove. That's the Marlar case I cited in the initial brief. Now, the idea that standing is part of the plaintiff's prima facie case is clearly stated in May. That's why, frankly, May is the best case I have on this issue for this particular case. It establishes that plaintiff has the burden to prove standing, and it also establishes that it's part of, that once it's properly denied, if the plaintiff fails to prove it, the remedy is remand and dismissal. As far as inferences that can be made from the servicing letter, that has nothing to do with whether it was in possession, it has nothing to do with whether it was endorsed. Because again, the issue here is Aurora claims to be servicing, it claims to be the agent for a principal. And
does it say who the principal is at that point either?
In the letter. The letter never says that. The letter never says that. And the complaint, as amended, identifies Deutsche Bank as trustee, but doesn't name a particular trust. That's why the specific identity of the trust was an issue at trial. So they don't actually connect all those dots. I've seen it done. We've all seen, I'm sure the court has seen records where the plaintiff is successfully able to link up possession, endorsement, even in the face of an amended complaint where the initial complaint like this one had a lost note count with no endorsements. It is possible to come into trial with records. Why are there no custodial records in this case? We don't know. Are there other records they possibly could have introduced to show possession? We don't know. Are there other records they could have introduced to show the date of the endorsement? We don't know. What we do know is they didn't have them at trial. And it's at the time this case was tried, it was very clear that standing at inception was something that virtually every district has required, at least at the summary judgment stage. Most of the trial cases have come down since then. But certainly, it was no surprise that they would need to prove that. They couldn't prove that the endorsements existed at the time they filed the lawsuit. They couldn't prove the endorsements were even on the note at the time of the lawsuit because they couldn't prove when the allonges were attached. Frankly, it was our position at trial, as the record shows, that the allonges weren't even original allonges. They were some kind of reproduction. But they didn't prove possession. They didn't prove endorsement. Those two requirements are clearly part of plaintiff's burden at the trial phase and at the summary judgment phase. There's no difference according to May, according to Ryan, according to Kiefert, according to Lacombe. So it's our position that this court should reverse this foreclosure judgment, remand to the trial court for an order of dismissal based on insufficiency of evidence of standing. And then, of course, the other issues we've raised in our complaint, some of those also deal with insufficiency of evidence. A couple of them deal with abuse of discretion as to proper evidentiary foundations being met. Those would be, that would be a remand for a new trial. But we think that the standing issue is so clear-cut that the court should remand and reverse for dismissal on that basis.
Okay.
Thank you very much.
Thank you.